Hello, good afternoon. So we are going to end with company law, this lesson 3 of the course of international commerce law. We have seen till now in the previous videos the main concepts in international company law, and in the last video we were considering the case law of the Court of Justice of the European Union. We have seen the most important decisions of the European Union Court of Justice, but the last one, Polwood decision that is connected with the two previous decisions, Cartesio and Vale. We have seen that in Cartesio and Vale, the European Union Court of Justice has introduced a new right to companies formed in accordance with the law of a member state, the right to transformation, to conversion of the company. We have seen that if we consider together Cartesio and Vale, the result is that a company converts itself into a company governed by the law of another member state. A company formed according with Hungarian law, for example, decided to convert itself in a company governed by Italian law, then this is a right according with the freedom of establishment in the Treaty on the Functioning of the European Union. This was new. We were commenting that in the previous video. And at the end of that video, I explained that maybe, I have no proof of that, but sometimes I was told that maybe these two important decisions, Vale and Cartesio, were in fact cases, false cases in some way, created to force the European Union Court of Justice to say what at the end the court has said. So this freedom of establishment. And the idea is that since decades ago, the idea of a transformation of companies within Europe, the idea of a regulation about the transfer of a statutory seat of companies within Europe was on the table. I mean, it was discussed that it could be good for European companies to have a European regulation or directive making easier the conversion of a company governed by the law of one member state into a company governed by the law of another member state. That is, the right to transfer the statutory seat of one company from one member state to another member state, and at the same time with a change of the law governing the company. The idea was that this could be good for companies within Europe. But this plan could not arrive at an end because the proposals about a directive on international transfer of seat of companies, that is the same that international conversion of companies, couldn't arrive at a good end. Why? Because there were political problems. There were also a political discussion about the convenience or the problems of such a directive. In some important actors in Europe, for example, some trade unions, thought that this possibility offered to companies maybe was not good for workers, for example. And as a consequence of these obstacles, the directive of international transfer of seat of companies, on international conversion of companies, couldn't be issued. The idea was, well, if we cannot obtain this result through the action of the European lawmaker, maybe the European Court of Justice can help us, in the sense that if the case law of the European Court of Justice, the European Union Court of Justice, establishes a right to the transformation, at the end, the lawmaker in Europe it cannot avoid the elaboration of a directive on the international transfer of seat of companies. This could be, I'm not sure, this could be the idea after, in the background of these decisions, Vale and Cartesio. And it's true that after these both decisions, Cartesio and Vale, the situation was not easy in Europe because, according with the case law of the European Union Court of Justice, companies have a right to move its statutory seat to another member state when this change of the statutory seat was joined with the change of the law governing the company. Remember case Cartesio in the previous video. This is a right according with the European Union law, but without a common legal framework to all the member states, it's very difficult to make this operation, to do a conversion of a company. It's very difficult because of technical reasons. For example, when we are doing an international conversion of companies, international transformation of companies, then we need to register the operation in the register of companies in the first country, the country in which the company is registered at the beginning of the operation, and this operation should be also be registered in the country, in the second country, in the country to which the company wants to migrate. But this registration of the operation in both countries, it's difficult without rules about the communication between registers. Without this kind of rules, it's possible that, for example, the company disappears in both registers, or the other problem is that the company could have both two registrations, a registration in the country of origin of the company and another registration, another file in the register of the country where the company has moved. For example, imagine that in the first country, in the country in which the company was originally incorporated, the company adopts the decision of moving to another country, and then this decision arrives at the register of companies of that country, and the register of companies in that country, the country of origin of the company, decided to delete the registration of the company because of the adoption of the decision of moving the company to another country. So we have deleted, we have erased the registration of the company in the first country, but in a second step, it's necessary to register in the second country the operation. Imagine now that when the company arrives at the second country, the authorities in the register of companies in the second country decided that the operation is not legal. So the authorities in the second country refuse the registration of the operation. Imagine the company has been deleted in the first register and has not been registered in the second register. So at the end, the company disappears. This is not impossible without a regulation, an accurate regulation of the operation, a accurate regulation of the operation compulsory for both registers, for the register of the company in the first country and the register of the company in the second country. Other possibility, imagine that the company adopts the decision of moving itself to another country, but this decision is not registered in the register of companies in the first country, and the company goes to the second country, to the register of companies in the second country, and in that register the authorities decided to register the company, register the operation. So the company has already been registered in the second country, but the registration of the company has not been deleted in the first country. So imagine the problem. The problem is that the same company has two different registrations in two different countries. So this is not good for the trust in the register of companies, because it's possible that the same company has, for example, different representatives according with each of the register of the company. So in an operation like this, in operation involving the transformation of the company, it's necessary to delete the registration of the company in the first country only when the company has been registered in the second country. And it's not, we must establish a way to avoid the registration of the company in the second country without deleting the register of the company in the first country. And all these things are impossible without a regulation covering all the countries involved in the operation. So, although the case law of the European Union Court of Justice, it was still necessary a European Union directive on the transformation of companies. But after Vale decision, the European Union lawmaker didn't start to work on this directive. The things continue being the same. So the situation we had 5-8 years ago, it was that according with the case law, the operation was possible, but we don't have a directive covering all the technical problems of this operation, the international transfer of seat of companies. This changed with the Polwood decision. The Polwood decision, it's a very important decision of the year 2017. In this decision, a Polish company, a company formed according with the law of Poland, decided to convert itself into a company governed by the law of Luxembourg. And at one point, when the company decided to went to the register of companies in Poland in order to register the operation, the change of the nationality of the company, the authorities of the Polish register of companies established that it was necessary the liquidation of the company. The liquidation of the company. Of course, if you need a liquidation of the company before the changing of the law governing the company, this is a serious inconvenience for the operation, because it's very expensive and it's it creates a lot of difficulties for the company to liquidate all the assets of the company. This is the same that killing the company, making the company disappear, and creating a new company, in this case in Luxembourg. And of course, this operation, it's possible, it was always, but this is not what the directors of the company want when they decide to convert the company into a company governed by the law of another country. They are not willing to liquidate the company, to kill the company, to take the company to an end, and to create a new company. They want to continue with the same company without liquidation and continue being the same company but governing by a different law. This is what implies a transformation of the company. The company doesn't disappear in any moment. The company is not liquidated in any moment, but then a point, the company till now governed by the law of Poland, for example, in this case, start to be governed by the law of Luxembourg, in the example we are considering here in Paul Booth case. So, as the authorities of the Register of Companies in Poland impose the liquidation of the company went to the courts, and the courts introduced a preliminary ruling before the European Union Court of Justice, asking about the compatibility with the European Union law of this obligation, the obligation of liquidation of the company as a previous step for the conversion of the company. And this was for sure a real case. I say in this case we are talking about a real company making a real operation. Maybe in Cartesian and Valley we are facing also real cases. I don't know, but there are some doubts about that. But in this case, there was a real economical reality after Paul Booth. This is a case in which for the first time it was really tested the conversion of companies in Europe before the European Union Court of Justice. And the European Union Court of Justice decided that it was not possible to avoid the operation, the transformation of the company, introducing the requirement of the liquidation of the company. The European Union Court of Justice established that in a case like that, the company has the right to transform without liquidation. The company to become a company governed by the law of Luxembourg, and after that decision, the company was effectively governed by the law of Luxembourg, by the law of the new state where the company want to transfer its statutory seat, and the law that the company desires to be the law governing the company. And the law of Poland cannot be imposed to that company from the moment of the transformation of the company. This is very important because it's the result of this is that the right of transformation is almost absolute. I mean, the law of the member states, in particular the law of the state of the origin of the company, cannot say almost anything about the transformation. As we don't have a regulation about the transformation of companies, we only have the case law of the European Union. The freedom of the companies to convert into companies governed by the law of another country is almost absolute. And at that point, the European lawmaker decided that it was necessary to introduce a regulation about the transformation of companies, the international transformation of companies within the European Union. At this point, at the point in which the European Union lawmaker realized that without this regulation, the companies can do whatever they want in the transformation, because any obstacle imposed by the law of the country in which the company has been incorporated, the state of origin of the company, any obstacle will be considered by the European Union Court of Justice against the freedom of establishment. This is a very important point. We have to realize that the European Union lawmaker started to act without a proper regulation of the international conversion of companies. The law of any state cannot establish any limit to the conversion of companies. And few months after the Polwood decision is October 2017, few months after that decision, the European Union lawmaker uses a proposal that was not intended to cover the international conversion of companies to introduce a regulation about the international conversion of companies within the European Union. At that moment, at the end of 2017, beginning 2008, there was on the table a proposal of a proposal for a modification of the Directive 2017 1132, Directive 2017 1132. This is a very important directive because this directive codifies all the directives on company law that has been implemented since 50 years ago. There were a lot of European Union directives on company law. It was almost a mess sometimes because so many directives, in some cases related with one directive with the other directives, it was a little bit confusing. And at one point, the European Union lawmaker decided to put all these directives together in a single directive, a directive intended to codify the European Union company law. And this directive was Directive 2017-1132. And short after the issuing of this directive, there was the intention of modifying this directive for some technical problems. We are not going to enter into that at that moment. Some technical problems, and also for some regulation about international mergers of companies. That was an operation. We are going to talk about this operation in a few minutes, and that could have some little change in this directive. So we have a directive of Directive 2017-1132, a directive on that codifies the European Union law on company law, and we have a proposal for the modification of this directive at the beginning of 2018. Well, at that moment, as the European Union Court of Justice has given to us the decision in the case Polwood, the European Union lawmaker decided to use this proposal to introduce a regulation on international conversions. And this proposal ended in a directive of 2019. It was published in November of 2000. I'm going to give you also this directive, and this directive of the end of the end of 2019. I'm looking for this directive at the moment. Yeah, it's Directive 2019-2121 of 27 November 2019, and it was published in December. The directive is of 27 November 2019, and it was published in December 2019. And this directive modifies the Directive 2017 1132. And now we have a codified text of the directive with the modification introduced by this directive of the year 2019. So I repeat the main idea. We have the case law. The case law at the end makes the European Union lawmaker to act, and the European Union lawmaker introduce a regulation on the international conversion of companies through a directive of 2019, 27 November 2019, a directive that modifies the directive 2017 that 1132, that is the directive that codifies the European Union law on company law. I know that it seems complicated, but as you have the video, you can go back and see it again. And as you are seeing now, you have here the reference of the different regulations, so you can check these regulations. And I hope that when you read the regulations, you understand correctly what I'm trying to explain. If you have some doubts, of course, we are going to see us again in next Tuesday, and we can discuss all the doubts you have about that. But the final idea is that nowadays, we already have a directive covering the international conversion of companies. And which what are we going to find in this directive? Well, the process of the process for change the law governing a company in Europe, the law that allows the companies to become companies governed by by the law of another member state of the European Union, it's, I think, very logical. First, the company, the administrative or management body of the company shall draw up the draft terms of the cross-border conversion, the plan, the proceedings of the conversion. This should be drawn up by the administrative body or the management body of the company, and these draft terms of the conversion should be have also a report of the same administrative or management body of the company. So the management body of the company, the administrative body of the company, the directors of the company should elaborate two different documents: the draft terms of the conversion and the report. And the report is the document explaining the reasons for the conversion. The draft terms explain what the company is going to do. And the report explains why the company is doing that, which are the reasons for the conversion of the company. It's also necessary a report made by independent experts. So we have the draft terms, we have the report of the management body or the administrative body of the company, and we have also the independent expert report. And all these documents should be open to the public, should be disclosure. So it means that all these documents could be known by the shareholders, the creditors of the company, and all the persons with interest in the conversion of the company. And all these persons with interest in the conversion of the company can make their allegations about the conversion. And they have also rights. For example, if we consider the shareholders, of course, a majority of the shareholders are going to agree to the transformation, because if a majority of the shareholders are against the conversion of the company, at the end the general meeting of the company won't approve the transformation. So the majority of the shareholders, of course, are going to be in favor of the transformation. If majority of the shareholders are not in favor of the transformation, at the end there will be no transformation. But it's possible that some shareholders, minority shareholders, are against the transformation. In that case, there is an obligation to compensate these minority shareholders. The minority shareholders has the right to dispose of their shares for an adequate cash compensation. The minority shareholders can give their shares back to the company and obtain the money that their shares have according with the value of the company. There is no obligation for the minority shareholders to continue being shareholders of the company when the company is governed by another law. The idea is, we are shareholders, for example, of a German company. If the majority of the shareholders decide to convert this company in a company governed by the law of Italy, well, they could do that, but we have the right to recover our money, to recover the money of our shares. We can dispose of our shares for a cash compensation. This is the right of the shareholders, minority shareholders. And the creditors of the company. The creditors of the company have also the right to obtain guarantees for their credits. The reasoning is as follows. We are creditors of a German company. If now the German company is no longer a German company, but an Italian company, maybe we are not happy with this transformation. Maybe our conditions for entering into business with an Italian company are not the conditions we are using with a German company. So we can obtain a guarantee for our credits over the company. This is the aspect of the creditor. So we have seen that till now there are shareholders with interest in the operation, creditors of the company, and also employees. The employees has also a right of information about the conversion, and they have also the right to maintain the participation of the employees in the governing of the company, in the ruling of the company. There are specific rules about the role of the employees and the associations representing employees of the company. So all these persons, all these actors involved in the operation has the right to know all the documents related with the conversion and to demand these guarantees. The minority shareholders, the recovering of their money for the shares they have in the company, the creditors, the guarantees they have the right to obtain for the credits they have over the company, and the employees the right to know how it's going to work the participation of the employees in the company after the transformation. So we have the draft terms of the conversion, the report for the conversion, the report of the independent expert. The first was the report, the drafters elaborated by the management or administrative body of the company, the report of the management or administrative body of the company, the independent expert report, and the disclosure of all these documents in order to allow the minority shareholders, the creditors, and the employees to obtain the guarantees the regulation established for all these stakeholders of the company. After the elaboration and disclosure of these documents and the knowing of these documents by the stakeholders of the company, the conversion should be approved by the general meeting of the company. When the conversion is approved by the general meeting of the company and all the guarantees we have talked to it now has been are a reality, then an authority in the country of the company should certificate that the proceedings had ended in the state of origin of the company. I mean, for example, in Spain, the register of commerce in which the company is registered should issue a certificate explaining that all the steps has been made in a legal way, that there was the draft terms, the report of the management body, the independent expert reports, the creditors had obtained the guarantees they deserve, that in case of minority shareholders they have obtained the money for their shares, etc. When all these steps had been implemented in the state of origin of the company, then is the moment to issue this certificate, and with this certificate the company can go to the state in which the company is going to be after the conversion. For example, a Spanish company converting into a French company, after obtaining this certificate in Spain, the company with this certificate goes to the French Register of Companies and says, well, we have already made all the steps in Spain. Now this is the certificate proving that in Spain we have done all things needed for the conversion. So now you, the authorities in charge of the French, in this example we are using now, authorities in the French Register of Companies should determine the legality of the operation from the French point of view. And the French authorities, the authorities of the country to where the company wants to migrate, should first study the certificate issued by the Spanish authorities, and when the certificate is correct, they assume that the process has been legally made in Spain. And then after that, these authorities should determine whether the process is also legal from the French point of view, because one of the points of the conversion is the transformation of the Spanish company, the company governed by the law of the country of origin, into a company governed by the law of another country. So the French authorities should determine whether the conversion is right according with French law. These new bylaws of the company are according with the French law, yes or no? If the transformation has been already made in a legal way according with the French point, according with the point of the point of view of the country where the company wants to migrate, then we have ended the proceeding. The company will be registered in the register of companies of its new country. I hope that this is clear. There are two different parts of the conversion. The first part is in the state of origin. The second part is in the new state of the company. In the first country, in the state of origin of the company, they should determine whether the draft terms of the conversion are correct, the report of the management body is correct, the report of the independent expert is correct, whether the minority shareholders have received the money they deserve or not, whether the creditors have obtained the guarantees they deserve or not, whether the information of the employees is correct or not. When all these things are correct, there is a certificate in the state of origin of the company. With this certificate, the company goes to the second state, and in the second state, the authorities determine first whether the certificate issued by the first authority is correct or not. This is a pure formal verification, and then they should determine whether the adaptation of the bylaws of the company and the rest of the documents of the company to the new law of the company is correct or not. When it's correct, then the company is registered in the second country. I hope that this is clear. We have almost finished, but almost. Why? Because there is another point. It's the communication between register. There is also the obligation of the register in the first state to take note of the conversion of the company, but the register in the first state should not erase the registration of the company before the registration of the company in the second state. So, for saying in that way, the registration of the company in the first state is freeze. The registration of the company still exists, but it's not possible to change it after the registration of the conversion of the company. But it's not deleted. Then, with this registration in which you cannot introduce any change, they are waiting for the result of the registration of the company in the second state. When the company is registered in the second state, the authorities of the second state communicate to the authorities in the first state that the process of conversion of the company has been completed. And at that point, the authorities in the first state erase the registration of the company. They remove the registration of the company of the register because there is a new register of the company in the second state. This is important because this communication of the between registers making possible the problems we have. I have explained before the problems caused by the fact that the registration of the company could be disappear in both states, in the state of origin and in the second state, and another problem that there are two registrations of the company in two different registers. This is not possible with the regulation in the Directive 2017-1132, the Directive on Company Law, according with the reform made in the year 2019. It's not possible because there is a communication between the registers, and the first register takes no note of the change, and from this point it's not possible to change the information about the company, and they wait till the registration of the company in the second register, and at that point, with the registration of the company in the second register, they, in the first country, erase the registration of the company. I hope that this is clear. It seems complicated, but it's very logic. The two steps and the steps in each of the countries. If there are any doubt, we can discuss that on Tuesday. And then we have seen conversion of companies. Now we have to consider merger of companies. Merger is a different operation, and it's an operation that sometimes is not well understood. Why? Well, because sometimes in the news, in the newspapers, in the media, they talk about mergers when they are not talking really about mergers in a technical point of view. When we are talking about mergers, we are talking about operations in which a company, at least a company, disappears. I mean, a merger by acquisition, for example, implies that an existing company is bought by a bigger company, usually, not always, but usually, and after this operation, the first company disappears completely. The shares of the company, the first company, disappear, and the owners of that share, the shareholders, receive shares of the company that has bought the first company. I mean, we have a company and another company acquires all the assets and liabilities of the company, and the first company disappears. The shares of the company disappear, of the first company, and the shareholders lost their shares, but they obtain in exchange shares of the company that has acquired the first company. In some occasions, in the media, they talk about mergers, and it's not really a merger, because when, for example, a company buy all the shares of other company, but the other company continue existing, this is not a merger in a legal technical point of view. It's an acquisition of the company, but not a merger. If we are talking about a merger, if we are saying a merger, that implies that at least a company has died, if you allow me this expression. A company disappears. Without this this assassination of a company, we are not facing a real merger. But there are a lot of operations that from an economical point of view are called mergers, and they are not mergers from a legal point of view. I repeat, when we are talking about a merger from a legal point of view, one of the companies disappear. One or more, because in some occasions it's like I have explained, that we have one company and a bigger company, and the bigger company buys all the shares of the smaller company, and the smaller company disappears. But in some occasions there are 2-3 companies that are acquired by a bigger company, or in some other occasions, we have 2 or 3 or 4 companies, and these companies create a new company that is the new owner of all the assets and liabilities of the former companies. And in these cases, all the companies involved in the operation disappear, and all these companies create a new company that is the company resulting of the merger. This operation is possible within each country with companies incorporated in the same country, but it's also possible with companies incorporated in different countries. And the proceedings for a merger are very similar in the essence of the proceedings for a conversion, because in these cases of mergers we have a draft terms of the merger that are the same for all the companies involved in the process. We also have reports of the management body and independent experts. We have also the obligation of disclosure of these documents. We have also the right of the minority shareholders of obtaining a compensation for their shares. We have also the right of the creditors of the companies involved in the operation, the right of obtaining warranties for their credits. We have also the information to the employees of each company. This is very similar to the proceedings we have seen in the international conversion of companies. And in that case, the draft terms of the merger should be approved in each of the countries of the companies taking part in the operation. Imagine if we have a merger with 3 companies, and imagine a merger in which the 3 companies disappear and they create a new big company, then in each company should approve the operation according with the rules of the country of the company, and after approving the operation, an authority of the country of the company should certificate the legality of the operation from the point of view of that country. So if we have 3 companies, a company in Spain, a company in Italy, and a company in France, and they create a company according with the law of Portugal. So we have 3 companies. The Spanish company should approve the merger according with the Spanish law. The Italian company should approve the merger according with Italian law, and the French company should approve the merger according with French law. The authority of Spain will certificate that the operation is legal according with the Spanish law. The authority of Italy should certificate that the operation is legal according with Italian law, and the French authority should certificate that the operation is legal from the point of view of French law. With these 3 certificates, the Spanish certificate, the Italian certificate, and the French certificate, the directors of the company go to Portugal, to the country in which the company that is the result of the merger is going to be registered. And then with these certificates, they go to the register of companies in Portugal. They show the certificates to the authorities in the register of companies in Portugal, and the authorities in Portugal, in the example we are using now, certificate whether the operation is legal according with the Portuguese law. When it's legal according with the Portuguese law, the authorities in Portugal register the new company that is the result of the merger, and the authorities in Portugal communicate to the register of the other companies that the operation has been complete, and then the authorities in Spain, Italy, and France delete the registration of these companies in each of these countries. As you see, the process is very similar to the process in the conversion of or the conversion of a company governed by the law of a European member state in a company governed by the law of another member state. And there is also another operation, that is the division of companies, that is the opposite, it's just the opposite to the merger of companies. In the merger of companies, we have different companies that disappear because they join in a different company, in a company already existing or in another company, and in the division we are facing a company that disappear because it's split between different companies. A part of the company is acquired by a company and another part of the company is acquired by another company. We are not to enter into the details of the division because it's also very similar to the merger proceedings. And as we have very few time now, and I have to say one thing more before ending this video, I have to stop here with the division. I have said that it's very similar to the merger, and as you have the directives, you can check the regulation in the directives, and if you have doubts, we can comment these doubts on Tuesday. So, conversions started with the case law of the European Union, but at the end there is a regulation according with the European Union law in the directive we have seen, Directive 2017-1132, modified by the directive of 27 November 2019. Mergers that they are following a proceeding very similar to the proceeding of the conversion, and also divisions of companies. And the last point in this lesson is about the European companies. European companies. When we are talking about European companies, what are we talking about? Well, before the Centros decision, do you remember Centros decision in the second video, I think, of company law? Before the Centros decision, it was difficult in some cases the recognition of companies incorporated according with the law of a member state. And as it was difficult, the recognition of companies, the recognition in one member state of companies incorporated according with the law of another member state, these operations we have seen till now, conversions, mergers, divisions, even establishing of branches of a company in another company, as we have seen in the Centros case, were very difficult. And the idea, it was that to avoid these problems, the solution would be creating European companies. I mean, companies not incorporated according with the law of a member state, but according with the European Union law. The law of the company is not the law of Italy, Spain, French, or the Netherlands, it's the European Union law. As is a company incorporated according with the European Union law, there are no problems of recognition because the company is the same company in Germany than in Italy or in Spain or in Portugal, because it's always a European company. A European company cannot be non-recognized, should be always recognized, because in fact there is no problem of recognition because it's a company governed by the law of the authority. As the company has been incorporated according with the European Union law, from the point of view of Spanish authorities, it's a company of his own. And this is the position also from the point of view of Italy or Germany. It's always a domestic company because it's a European Union law company. This was the idea. And after a lot of years of working, at the end, the European lawmaker created two main European Union companies. The European company, Societas Europea, that is regulated by the regulation 2157 2001, a regulation of the year 2001, and the European Cooperative Society, that is regulated by a council regulation of the year 2003. European society, European company, Societas Europea, that is similar to a public company, a Sociedad Anónima in Spain, a Société Anonyme in France, Aktiengesellschaft in Germany, and a European Cooperative Society that is a cooperative company that is also very common in all the European states, a company in which the partners are also workers of the company usually. And these are the two main types of European companies. And when this kind of companies created, I repeat, by regulations of 2001, Societas Europea, and 2003, European Cooperative Society, as this company, and in the moment that these companies were thought, the idea was imagined, these kind of companies should be very, very important because, as I have said before the Centro's decision, the international operations within Europe using domestic companies, using companies incorporated according with the law of each country, were very difficult. International operations as establishment of branches in countries different of the country of incorporation, international conversion of companies, international transfer of seat of companies, international mergers, international divisions, were difficult divisions using domestic companies, using companies incorporated according with domestic law. And the idea is that when a company wanted to do some of these operations, should be transformed into a European company. This was the idea. But as we, in 1999, we had the Centro's decision that allows all the domestic companies, companies incorporated according with the law of each member state, allows all these companies this kind of operations that we have seen in the previous videos. So the utility of these European companies is not so relevant because nowadays you have the option to do these operations through the European companies or through the domestic companies, the companies incorporated according with the law of each member state. So at that moment, European companies are important, of course, but are not so important as they would be in the case that the Centro's decision doesn't exist. In a world without the Centro's decision, all international operations in Europe will be made through European companies. As we have the Centro's decision, the persons working in the international commerce have the possibility to choose between the European companies and the companies formed in accordance with the law of the member states. This is the idea. So, and this is the end of the lesson 3. We are going to meet on Tuesday at 12 o'clock. I have already shared with you the link for our meeting through Teams. If you have any doubt of any of the videos, we can discuss that doubts. I know that it's in some way technical, this lesson, and it's normal if you have doubts, and we are in this in this new methodology that is for sure is not the ideal methodology, because it's better to have a direct contact in order to express our doubts. But as we are going to have this contact on Tuesday, and you have the possibility of seeing or watching this video before that, I hope that we can resolve these doubts on Tuesday. On Tuesday, I will, between tomorrow and the day after tomorrow, I'm going to give you feedback of your exercise about company law, the second exercise. I have already given you feedback about the sorry, a problem with the camera. I have already resolved that. I was saying that. Yeah, I have already about the first exercise, the first exercise in company law, the exercise about the new Article 54 of the Treaty on the Functioning of the European Union. Between tomorrow and the day after tomorrow, I'm going to give you feedback about the second exercise that I recognize it's more difficult than the first one. I'm going to see what have you done in this exercise. We are going to comment that on Tuesday, and on Tuesday I'm going to give you another exercise on company law, and if you want, we can have another meeting through Teams on Friday, address to the doubts you have, because next Tuesday 28th, we have another practical exercise over only lesson 3. So we are in the next week, in the week beginning the 20th April, we are going to try to resolve all the doubts about company law, and I hope that you will be in the best condition on April 28 to resolve the second practical exercise we have, and practical exercise about company law. That's all. We